jurors in this case. Now, the lawyers will present evidence according to what we call the rules of evidence. It's up to me to enforce those rules and determine what evidence may be admitted for you to consider when you deliberate on your verdict. You will be the sole judges of the facts, the credibility of the witnesses, and the weight to be given to the testimony of each witness. Later, I'll instruct you on the law, and then you apply the law, as I give it to you, to the facts which you're going to learn from the witness stand. It is your sworn duty to accept the law as given to you by the court. You are not entitled to apply your own idea of what you wish the law might be. Do you understand that? All right. Now, the trial procedures that we follow are this. First, the attorneys will outline what they expect their evidence will be. These are called opening statements. They're not evidence, they're simply a preview of the claim of each party, and they're designed to help you follow the evidence as it's later presented from the witness stand. The state first offers its evidence, and the defendant may offer evidence if he desires. If the defendant does present evidence, then the state is given an opportunity to present rebuttal evidence. Thereafter, the trial concludes with arguments of counsel and instruction of law by the court. And at that point, you'll be sent to deliberate on your verdict. It is essential that you be fair and attentive throughout the entire trial. You must not discuss this case among yourselves or anyone else. You're not permitted to discuss this case with anyone, and you must not form or express any opinion on the case until it is finally submitted to you. Now, it may be difficult for you to understand that you may not discuss this case even though it's among yourselves as jurors until it's finally submitted to you. The reason for this is we want you to have all things in an orderly fashion. Opening statements followed by evidence, followed by instructions of law, and then final argument. It would be unfair and premature if you would begin discussing this case until you have all the evidence before you that's necessary for a proper decision. You must explain this to your family and friends. They will be curious about what you're doing here, and you have to tell them that you can't discuss it beyond saying that you're on a jury. Now, when the trial is over and when your jury service is complete, you'll be released from this instruction, and at that time you can discuss this case with anyone you want. You can talk about your experiences as a juror, you can talk about the attorneys, you can talk about the judge, you can even talk about what goes on in the jury room. But you have to wait until the case is concluded, so we ask you to control your natural desire to discuss the case both here and at home. During the trial, you must not talk to the attorneys, the parties, or the witnesses. By the same token, those participants in the trial must not talk with you. If anyone should attempt to discuss this case with you, you are duty-bound by your oath to report that matter to me or to the bailiff. Now, I'd like to discuss the issue of electronic communication. During the course of this trial, you're prohibited from texting or blogging or posting on Facebook or Twitter or Instagram or any place else about this case. You may not investigate or attempt to obtain additional information about this case outside the courtroom. And if you're like me, when you have a question, you're quick to turn to the internet for answers. In the course of this trial, it's important that all the information you receive regarding this matter for you come to you in and from this courtroom. Everything you will need to know to make a decision will be given to you here. Now, any violation of these orders could cause a new trial or could require a penalty for disobedience. In fact, as jurors, you could be made to pay the costs of jurors and attorneys for a subsequent trial if necessary. Now, I'm not going to repeat these instructions every time we take a recess, although you must remember that these general instructions do apply to your conduct throughout the entire trial. There may be occasions when we have a bench conference. That is when the attorneys wish to speak with me privately. During those times, you can stand up, you can stretch, you can feel free to talk amongst yourselves. However, don't talk about the case. You can talk about the weather or something like that. Those bench conferences are usually held at that end of the bench. And we have white noise, which is supposed to help cover some of the discussion. So anyhow, it's not intended for you to be involved in those. Feel free to stand up, stretch, do whatever. Now, before we begin opening statements and before the actual taking of evidence, let me give you some instructions on the evidence you may anticipate receiving during the course of the trial. Let me also instruct you on the weight to be given to the evidence and how to determine the credibility of the witnesses that you will hear. First of all, evidence is defined as all of the testimony received from the witnesses and any exhibits or actual physical items that are admitted during the trial. Evidence may be direct or circumstantial or both. Direct evidence is testimony given by a witness who's actually seen or heard the facts to which they may testify. And direct evidence includes exhibits admitted during the course of the trial. Evidence may also be used to prove a fact by inference. This is referred to as circumstantial evidence. Circumstantial evidence is the proof of facts by direct evidence from which you may infer other reasonable facts or conclusions. In the absence of direct evidence, circumstantial evidence by itself will justify a finding of guilty if it is so convincing as to exclude a reasonable doubt of the defendant's guilt. Where the evidence is both direct and circumstantial, the combination of the two must satisfy you of the defendant's guilt beyond a reasonable doubt. If the circumstances in the case create inferences that are consistent with either innocence or guilt, those inferences must be resolved in favor of the defendant's innocence. Now, as jurors, you will be the sole judges of the facts, the credibility of the witnesses, and the weight to be given to the evidence. To weigh the evidence, you must consider the credibility of the witnesses. Apply the tests of truthfulness which you're accustomed to applying in your own daily lives. In deciding the weight and value of the testimony, take into account the following factors: the testimony itself, the intelligence of the witnesses' ability to observe the things to which they have testified, the quality of the witnesses' memory, their appearances, their friendships, their prejudices, if any, and how that witness may be affected by the verdict in this case. Also consider whether the testimony is supported or contradicted by other evidence. Now, if you do find inconsistencies or differences between the testimony of a witness or as between the testimony of different witnesses, decide whether the difference goes to an important matter or to a relatively unimportant detail, and whether it results from innocent error or from actual untruthfulness. If you do find differences or conflict in the testimony, it's up to you to resolve them and decide where the actual truth is. You are not required to believe the testimony of any witness simply because that witness is under oath. You may believe or disbelieve all or part of the testimony of any witness. It's your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. Now, we've mentioned reasonable doubt a number of times today. Let me define that for you for the first time. I'll also provide this definition for you at the end of the case and in written form. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. We mentioned earlier the evidence does not include the indictment, the opening statements, or the closing arguments of counsel. Opening statements and closing argument are designed to assist you, but they're not evidence. As I mentioned before, the indictment simply brings the defendant into the courtroom, but it is not evidence. They have not yet been given notepads, have they? No. Go ahead and issue those if you would. Now I'm going to give you notepads. Some people like to take notes, some people do not. That is a matter of your own choice. If you decide to take notes, don't become so engrossed in the note-taking that you fail to observe the witnesses as they testify on the stand, because that observation is an important part of their testimony as well. Now, you can't take your notepads home with you overnight or edit those notes at home. When you begin your deliberations, you must not assume that a person who took notes is going to know more about the case than someone who did not take notes. In note-taking, bear in mind that although the court reporter is taking a verbatim transcript of the proceedings, you will not have that transcript available to you in the jury room. Now, as I said previously, the judge and the jury have separate functions. The fact that I may be looking something up on the computer or texting or writing notes or something like that doesn't necessarily mean that that's something that you should or should not pay particular attention to. Your job is to determine the facts. My job is to assure that there is a fair trial. So we have different jobs, okay? Now, we do have media in the courtroom. They are familiar with the rules that jurors are not to appear in any photographs or video. So I think we can rest assured that will not happen. They will be taking video from that corner for certain. I don't know if you're planning on video. Okay. If there's a witness that does not want to be on video, they can certainly inform the media and they will not be part of the video. But in any event, as jurors, you will not be on that video in any way. So at this time, we're going to move to opening statements. Again, opening statements are a preview of what the attorneys believe their evidence will be. Mr. Mulligan?
Yes, we may just make a joint motion for separation of witnesses.
All right. Good. Are there any witnesses in the courtroom? All right. So, counsel, I will leave it up to you to make sure that you have no witnesses in the courtroom other than those set to testify.
Thank you. Thank you.
All right. Opening statements, please.
Thank you, Your Honor. Ladies and gentlemen, this happened on March 27th, 2013. So it was a few years ago, almost 3. On March 27th, 2013, Amy Ross was staying in the home of her sister, Andrea Swope. Also in the home was Andrea's 13-year-old daughter, Summer Swope. So there were 3 ladies staying in the home in Rollo Carver out on Lights Road. Amy had left her husband, the defendant, Randy Ross, and had been living with Andrea for some time and was in the process of moving. So they woke up early on the 27th of March, and on the 27th they had arranged to meet some people at Amy's house, the house that she had shared with the defendant, his husband and wife, and they were going to remove some large items, furniture and so forth, from the house. They did that, and they arranged to meet so early in the morning because they figured that the defendant would be at work at that time. That time he worked at for the village of Pemberville in water sewer treatment, that kind of pursuit. And he went into work fairly early. So they met over there and were able to load up the furniture and take it back to Andrea's home that she shared with her daughter Summer and her sister Amy. After moving the furniture back, they took Summer up to school to go to track practice. This was on March 27th, so it was spring break. There was no school during that period of time. While Summer was at track practice, Amy and Andrea went to Subway. They got some sandwiches, and Amy actually brought hers home with her and was eating that later on in the day. Well, at the same time this was happening, taking Summer to track practice, picking her up and bringing her back, Randy Ross was leaving work. He left work, I think Gail Lorbridge, Mr. Gail Lorbridge will testify that Randy Ross left work about 10:15 that morning, saying that he had to meet his wife. The next time that we pick up Randy Ross, we have a friend of his, or an acquaintance of his, Mike Claus, whose proper name is Peter Claus, but he goes by Mike. Mike saw the defendant coming into Oak Harbor on the bridge from the direction of Fremont. Well, Amy and the defendant's home was is a Fremont address. They lived in rural Fremont. So he left work in Pemberville 10:15 and is seen later on in the day coming back into Oak Harbor from the direction of Fremont. Mike recognized the defendant. The defendant went off the other way, and Mike went into Fremont with his children, who were also off of school because of spring break. I believe Mike will testify that he took them to a batting cage in Fremont, and that before they left the batting cage, he had received information from an acquaintance that Amy Ross was dead. So Amy is sitting at the table in Andrea's house. She's enjoying a Pepsi and her Subway sandwich, and the defendant showed up at the house. He was told not to come to the house, but he came up there anyway. The door was locked, and he knocked on the door and wanted to gain entrance. They refused him entrance, and the next thing we know, the defendant busted the front door open and came in uninvited, unwelcome. He's a trespasser at this point. He's essentially a burglar. There were angry words, shouting. The mother of Summer, Andrea, told Summer to get upstairs, get away from this. Summer went upstairs to her bedroom. Amy and the defendant were talking angrily when Andrea also went upstairs to Summer's bedroom. And then Amy came upstairs to Summer's bedroom. The two older ladies, Andrea and Amy, tried to hold the door shut from the defendant coming in, but they could not. The door would not lock, and he already had gained some purchase on the door before they could close it. So they could not hold him from coming in. He pushed in the door. Summer and Andrea got into a small closet. The closet had no door on it, so when they were in the closet, it was open to the rest of the room. It's a fairly small bedroom, and you'll have pictures of the bedroom, pictures of the closet. As they got into the closet, the defendant grabbed Amy by the hair, pulled her back, and said something to her like, you think you're going to get all my stuff, or you think you're going to end up with everything. Andrew will testify about that. He had a gun. He walked in with a gun into the house. I think the testimony will be that there were no other weapons in the house except for what the defendant brought with him. He brought a .40 caliber gun with him. Andrea and Summer, I expect, will testify that while they were in the closet, the defendant stood up and pointed the gun in the direction of Amy. Andrea, I think, will testify that he was so close to her that without moving, she could have reached out her hand and touched that gun. And the gun fired once, pulled the trigger, hit Amy right square in the chest, went through her heart, and she's dead. Andrea and Summer then saw the defendant take that same .40 caliber gun and put it under his chin and pull the trigger. The gun went off. He did not die, obviously. Put the gun up again to his chin, pulled the trigger again, did not die, but went down, I think to his knees, and was moaning and mumbling, according to Andrea. Andrea then is screaming at Summer, "Get out, get out, get out." Summer left and locked herself in the bathroom. Andrea had the presence of mind to pick up the gun because she could tell that Randy Ross was still alive, and she put the gun on the windowsill. I think she'll testify that she would have thrown it out the window, and that was her first inclination, but then she thought she didn't know where Summer went, and if she threw the gun outside, would it go off and accidentally hit someone. So she put it on the windowsill. The defendant then got up and walked out of the bedroom after having wounded himself twice in the head. Walked out to the front porch. 911 is called. The first responder is Chief Jody Hatfield. Chief Jody Hatfield from the Carroll Township Police Department say that when he got there, Randy Ross was out on the front, walking back and forth. He made him lie down. He patted him down. EMS came. The defendant was life-flighted. EMS went up to render services to Amy, but she was gone. She's dead. The Ohio Bureau of Criminal Investigations came out to the scene, and they did a crime scene analysis. But as you can imagine, there's 2 eyewitnesses, so they knew what was going on. There wasn't a lot of necessity to try to work backwards from the evidence to figure out what happened because they had the testimony of the 2 ladies, Summer and Andrea. So we have, for instance, bloody boot prints that lead from the bedroom down to the stairway, and they can testify that the boot prints are the boot prints of the defendant. But in the grand scheme of things, all of that technical evidence doesn't amount to much. I mean, because we have the 2 eyewitnesses. So there's not a lot of crime scene investigation kind of evidence that you need to consider, although it's there. We have some DNA, we have boot prints, we have ballistics from the firearms examiner. But at the end of the day, what we have are 2 young ladies who saw, witnessed their sister and aunt murdered in cold blood by the defendant, and the defendant shooting himself twice. Thank you.
Thank you, Mr. Mulligan. Mr. Phillips?
Mr. Ross did not go to that house to commit an aggravated robbery, burglary that is. He did not go to commit a kidnapping. The evidence will not show he went there for those purposes. What the evidence will show is that he went there with the intent to rekindle his love for Amy. He knew that he was losing control of the situation. He knew that if he didn't act soon, And that, it would never be the same. He felt his world coming. He did go there for those reasons. Now, as you listen to this testimony, listen carefully with the evidence that suggests that it was an aggravated burglary. So listen carefully to the evidence that said trespass. Because that evidence isn't going to be there. So we don't know what went on in that house then. What we do know is that Mr. Ross was feeling the walls coming down. When those walls were coming down, he knew that he had to do something. Thank you in advance for listening to us in these next few days. I don't expect that it's going to be an easy job for you. But we have confidence in you, and we would like you to just pay close attention. Yes,
Could you speak up a little?
thank you. We,
Would you want to try the microphone? Pardon me?
Mr. Butler.
Okay, well, can I see a show of hands? Is anyone having difficulty hearing Mr. Kokovis?
I live at my house.
If you'd like to move closer, you certainly may.